Thank you for joining us today. The webinar topic for today's presentation is the Rent Stabilization Ordinance in the City of Los Angeles. This presentation is being provided by the Los Angeles Housing Department, and it is intended information for residential units located within the boundaries of the City of LA, not for commercial units, and not for properties that are located outside the City of Los Angeles. Today's topic will cover the Rent Stabilization Program, and there are 9 broad categories that will be discussed today: registration of rental units, rent increases, eviction reasons, relocation assistance, filing of eviction notices, tenant buyouts, posting of notifications, the tenant anti-harassment ordinance, and lastly, we will discuss the eviction for non-payment of rent when the amount owed is less than or equal to the fair market rent for that particular unit. First, owners and tenants must identify whether or not their property is located within the boundary of the City of Los Angeles or is located outside of the City of LA within the area of the unincorporated county or other cities. On your screen, you see an image of the Los Angeles city map. These are the areas that are under the jurisdiction of the City of Los Angeles. One quick way to identify if your property is in the city is to identify if you pay your water or electricity bill to the Department of Water and Power, DWP. If you do not pay your utility services to DWP, then your property is not located within the boundaries of the City of LA. Additionally, the City of LA receives enforcement services from the Los Angeles Police Department. Secondly, it's important to identify if the property that is located within the City of Los Angeles is also subject to the Rent Stabilization Ordinance. The general rule is that properties that were built on or before October 1st of 1978 are subject to the Rent Stabilization Ordinance if they're located in the City of LA. Additionally, there are new units that were built after July of 2007 that may also be subject to the RSO if they were built after an Ellis Act filing was done with the Los Angeles Housing Department. In general, we have about 650,000 rental units that are subject to the RSO. If you're still not sure if your property is regulated by the Rent Stabilization Ordinance or the RSO, you can go to the website cemas.lacity.org and enter the property address. Once the address is entered and you search for your address, you will see search results. Part of the search results will include different accordions. The one that you want to look at is the one at the bottom that says housing. Within this accordion, there is a category labeled Rent Stabilization Ordinance. If it says no, that means that the property does not have any units that are subject to the RSO. If it says yes, that means at least one or all of the units at the property are regulated by the RSO. Additionally, you can send a text to the telephone number 855-880-7368 and send the word RSO. When you do that, it will ask you to enter your address, and it will respond to you if that address that you've entered is subject to the RSO or not. Registration. Units that are subject to the RSO must be registered in order for an owner to legally collect rent from a tenant. The registration process contains two different steps. First, the owner must pay registration fees. The registration fees include a $38.75 per unit that must be paid for each RSO unit, and an additional $67.94 per rental unit for our SCEP program, or the Systematic Code Enforcement Program. Once these fees are paid, the landlord may pass through 50% of the costs to the tenants, which may only be collected on a monthly basis, as long as the owner provides a 30-day written notice to the tenant that they will be collecting this monthly surcharge. Specifically, the surcharges that an owner may recover from the tenant to compensate them for the registration fees is $1.61 per month for the RSO fee and $2.83 per month for the SCEP fee. The second step of the registration is completing the rent registry form. The rent registry form is the form that you see in the middle on your screen. It's green. This form collects the rent amount that an owner collects from the tenant and additional details as well. Both the rent registry form and the payment of the registration fees can be done online. The fees can be paid online at housingbill.lacity.org, and the rent registry form may be completed online at registerlarent.org. Both the fees and the rent registry form must be completed in order for an owner to receive a certificate of registration and legally collect rent. There are two types of rent increases that an owner may collect from a tenant. One are rent increases that do not require approval from the housing department. So the only thing the owner must do is provide written notification to the tenant. And the second type are increases that require LHD approval, which will require the owner file an application with the housing department and obtain approval from the housing department prior to collecting the increase. The rent increases that an owner may collect, or the surcharges that an owner may collect that do not require LHD approval include the category of vacancy decontrol, annual allowable rent increases, additional tenant rent increase, and pass-through for installation costs of a smoke detector or carbon monoxide detector. Vacancy decontrol means that an owner may charge market rate for the unit if the tenant that was occupying the unit voluntarily moves out, is evicted for non-payment of rent or a lease violation, or non-compliance with the tenant habitability plan, or if the tenant is evicted for compliance with a city attorney order. If this is the reason that the tenant moves out, an owner may set the initial rent for the subsequent tenant at market rate. However, all rent increases subsequent to the tenant moving in will still be regulated by the RSO. Condos also may not be regulated by the RSO if the tenants that were there, moved into the unit after December 31st of 1996. If the tenant was there prior to December of 1996, then the tenants are fully protected by rent control, and the rent increases cannot be applied at market rate and must comply with the RSO percentage that's allowed for the year. The rent increase that is allowed currently for an RSO unit, which can be applied once every 12 months, is 4%. This 4% is in effect from July 1st of 2024 to June 30th of 2025. Starting July 1st of 2025, the percentage may change. Additionally, an owner may collect 1% for gas and 1% for electrical service if the owner pays for the entire utility on behalf of the tenant. Therefore, this year, if an owner pays for both gas and electrical service, an owner could apply a 6% rent increase to the unit. Keep in mind that the rent can only be increased once every 12 months. And a written 30-day notice must be provided to the tenants if the rent increase is 10% or less. At the same time, the security deposit may be increased by the same percentage. So if a tenant paid a security deposit when they moved in, then an owner may take that security deposit and apply a 4% increase and ask the tenant to pay an additional 4% of the security deposit to the owner. More on security deposits. Once an owner has collected a security deposit from the tenant, there are two ways that an owner may pay or must pay interest to the tenant. One is using the simple interest rate as listed above, which is currently 0.52%, or the owner may pay the actual amount earned on the security deposits, which would require an owner to provide to the tenant a copy of the bank statement indicating the earned interest for the year. This rule applies only to RSO units, and only if a security deposit was held for at least 1 year. The interest can be paid monthly or yearly, depending on how the owner decides, and can be paid to the tenant as rent credit. Once the tenancy ends, the landlord must include all accumulated interest in the same manner as when a security deposit is returned. Rent increases for additional tenants. An owner may apply a 10% rent increase for an additional tenant with proper written notice, so long as it's not for the first minor dependent child that's added to the tenancy. An owner must notify the tenant of this increase within 60 days of having actual or constructive knowledge that the additional tenant was added to the unit. So this is very important. If the 60 days are missed and the owner knew or should have known that the additional tenant was added, then the owner may not apply the 10% rent increase. Rent increases that do not require approval also include a fee for a smoke detector or a carbon monoxide detector that's required by law. The amount an owner may collect as a surcharge is $3 per detector, and it requires written notice with 2 months of installation. And we do have more detailed RAC regulations that you can review. It's the RAC Regulation 340. Moving on to rent increases that do require approval by the housing department. There are a total of 5 rent increases that require approval by the department. And then the 6th item on the list is an exemption that the department can process for an owner, which would allow the owner to set the rent at market. The first type is a capital improvement program, which includes things like painting the unit, landscaping, fixing doors, windows, or the common area improvements that have a life expectancy of at least 5 years. If an owner does these improvements to a property, they may pass through a certain amount of the cost to the tenant as long as the owner applies with the housing department and gets approval from the housing department. The application for a capital improvement surcharge must be filed within 12 months after completing the work. If the application is filed after 12 months, then the owner is not eligible for the surcharge. Depending on the total cost of the work, the monthly surcharge will vary, but it can never be more than $55 per month for a 72-month period, which typically will be sufficient for an owner to recover the half of the expense of the improvements. Second type of program is primary renovation program. So this is a little different from the capital improvement program because a primary renovation is typically improvements that are pretty extensive and that will replace or substantially modify the structure, the electrical, the plumbing, the mechanical aspects of the building, or they will result in seismic retrofit or hazard abatement of lead and asbestos, which require a permit. If an owner engages in this type of improvement, then they must file a tenant habitability plan with the department, which is essentially a plan that describes how the owner will mitigate the impact of the tenant during construction. And it will also require that the owner provide temporary relocation or permanent relocation to the tenant, depending on how long the work takes. And secondly, the owner, once the work is completed, the owner can apply for a primary renovation surcharge or a primary renovation rent increase. They must file an application within 12 months of completing the work. And if approved, the department will allow an owner to collect a maximum of a 10% rent increase on top of what is typically allowed in order to recover the expense of the work that was done, of the primary renovation work. Seismic retrofit program also requires approval from the department, and it too requires a tenant habitability plan. Once the work is completed, the owner must file an application within 12 months of completing the work. And if approved, they will be allowed to apply a temporary rent surcharge at a maximum of $38 per month, collected over a period of 120 months or longer if needed to collect the full amount that the department will authorize the owner to recover from the tenant. Note that seismic retrofit may also include retrofit to common areas, such as parking areas that could be passed through to the tenants. Rehabilitation program requires approval from the department, and this type of work is typically work that's required by a government order from the housing department or building and safety as a consequence of maybe a change in the law that suddenly requires improvements to the property, or as a consequence of damage from fire or earthquake or a natural disaster. If approved, the owner will be allowed to recover 100% of the expenses. However, it is done as a temporary rent surcharge over the average of a 5-year period or 60 months, but it could be extended if needed. The maximum surcharge is $75 per month. The just and reasonable program. This is also an approval required rent increase where an owner who applies can be approved for a permanent rent increase if they can establish that their operating expenses are higher than their income. Operating expenses do not include mortgage, but it may include things like maintenance of the property, general maintenance of the property, and other factors. So it's a very detailed program that has a bulletin and an application. So for more details, you could always visit our LAHD website and look up the Just and Reasonable program. Lastly, the luxury exemption will allow an owner to permanently exempt the unit from the RSO, which means the housing department will not regulate rent increases, and that an owner could increase the rent to market without any regulation from the city. However, an owner has to establish that the monthly rent charge for the unit on or before May of 1978 met certain requirements under the municipal code to qualify the unit for the luxury exemption. Examples of evidence that could establish this are rent canceled checks, notarize rent agreements, or just sign rental agreements. So this goes back quite many, a number of years. So an owner does have to work closely with LHD staff to determine how to best prove that the rent in 1978 was the amount that the municipal code required. Next are the two types of evictions. We have at-fault evictions and not at-fault evictions. When the tenant is at fault, an owner may terminate the tenancy for non-payment of rent, violation of a lease, nuisance, drug or gang activity, using the unit for illegal purpose, failure of the tenant to renew a lease agreement, refusal to the landlord to access the unit, having a subtenant that is not approved by the owner, and a tenant's failure to relocate to another unit as required by a tenant habitability plan. Evictions that are not at fault include owner, family, or manager occupancy, evictions for the purpose of demolishing or removing the units from the rental market, compliance with a government order, such as when a garage has been converted to a residential unit without permits, conversion of a building of a regular apartment to affordable housing, conversion of a residential hotel to another use, typically a commercial hotel, or if the property is being foreclosed by HUD. All of these no-fault evictions require that the owner file a declaration of intent to evict with LAHD and pay relocation assistance to the tenants. General requirements for eviction under the RSO are that an owner may only evict a tenant for one of the legal reasons under the RSO as previously described. If it's for a no-fault reason, the owner has to file the declaration of intent to evict and give proper written notice to the tenant, which typically is 30, 60, 90, 120 days, or up to 6 months, depending on what state law may require. And of course, the owner must pay relocation assistance for no-fault evictions. Relocation assistance. The relocation assistance amounts are located on your screen, and they range from $10,300 to $25,700 for most of the no-fault evictions under the RSO, depending on tenant's income, length of tenancy, and depending on whether or not a tenant is a qualified tenant, meaning disabled, elderly, or if there's a minor child in the unit. There are some exceptions to these amounts, but they're very limited. For example, if an owner will evict for landlord, family, or resident manager occupancy, and they meet the requirements under the mom and pop rules, then the owner may only pay $9,900 or up to $19,950. So they are slightly lower amounts than the regular relocation amounts. But to qualify for that, the owner has to be a mom and pop owner, which essentially means they don't own more than 4 units on the property and maybe a separate single family dwelling on a separate lot in the city of LA. So no more than 5 total. And the 5th one must be a single family dwelling. So if an owner owns more than 5 units in total in the city, they will not qualify for mom and pop. And if they're evicting for a reason other than owner or family occupancy or manager occupancy, they also will not qualify for the mom and pop amounts. This chart does discuss the single family dwelling amount, which is 1 month's equivalent of rent. So it's a very different amount, very different rule, but this does not apply to RSO units. This 1 month's rent is only for units that are subject to the just cause ordinance, which is not the topic of today. But just know that generally, if it's 1 unit on the property, a single family dwelling, the owner might be eligible to qualify to pay relocation equivalent to 1 month's rent, but it does not apply to RSO units. Next topic is an owner's responsibility to file copies of eviction notices with LHD. The Los Angeles Municipal Code requires that an owner file a copy of all eviction notices that are issued, meaning any 3-day notice, 30-day, 60-day, 90-day notice that the owner serves on tenants. That has to be filed with our department within 3 business days of when it is served on the tenant. Although an owner could mail in a copy to the department or drop it off in person at one of our public counters, we recommend that it be done online, because that way the owner can ensure that the notice is received timely and can verify that it was actually received and the date that it was received. To do that, the owner should go to our LHD website at housing.lacity.org/eviction-notices. On that website, the owner will receive information about the program and instructions on how to file a notice online with LAHD. The notice, if the notice is not filed or not filed within the 3 business days, then it is an affirmative defense to an unlawful detainer case. Another important point is that all notices to terminate that are based on non-payment of rent must include the number of bedrooms of the unit. Next topic is the tenant buyout notification program. A tenant buyout is a written agreement where the landlord pays the tenant money or some other benefit for the tenant to voluntarily move out of the unit. It's important to note that tenants are not required to accept this offer. They can negotiate the offer. They can negotiate the amount. They can negotiate the amount of time. It really is a private agreement that both parties can decide how much money will be paid and how much time will be given to the tenant to move out. However, under the municipal code, the owner must give the tenant a disclosure notice of tenant rights, which you see an image of on your screen. It's a 2-page document. This must be given to the tenant either before or at the same time as the agreement is given to the tenant, so that the tenant may review it. The tenant who does sign an agreement to move out voluntarily has the right to change their mind and rescind the agreement within 30 days after they sign it. Or they also could get longer to change their mind if the owner did not comply with all of the requirements of the Los Angeles Municipal Code. Specifically, one of the requirements is that the owner must file the form and the agreement that are signed within 60 days to LAHD. If it is not filed within 60 days to LAHD, then it does not comply with the law, and the tenant has the option to change their mind at any time before they move out. Posting notifications on the property. An owner must post a rental protections notice on the property, and this was effective in January of 2023. It must be posted in an accessible common area of the property. So the laundry room is a great example of a common area. And if you don't have a laundry room, then the owner must find the best place where the notice will be visible in a common area to all tenants. Additionally, the owner must ensure that they also give the tenant a copy of the certificate of registration, which the owner obtains from the housing department after they have paid the registration fees and completed the rent registry form. Tenant anti-harassment ordinance. The anti-harassment ordinance is effective since August of 2021, and it applies to all residential units in the city of LA. It has a very specific definition of what harassment is, and there are several examples on the slide that could be viewed as harassment by an owner against a tenant, such as taking away services, refusing to do repairs, entering the apartment without notice, threatening the tenant, and so forth. There is various ways that harassment could be defined. If there is harassment, a tenant can file a complaint with the Los Angeles Housing Department, and the matter will be reviewed to determine if there's evidence of harassment. A tenant should always keep evidence of any harassment that they view with dates and details so that they can provide that to the housing department should they file a complaint. Evictions for non-payment of rent when the amount owed is less than or equal to the fair market value of the unit. Although non-payment of rent is a permitted reason to terminate tenancy, there is a restriction for owners. If the amount of rent that is owed is less than the fair market value of the unit, according to the bedroom number of the unit, then the owner cannot evict the tenant for an amount less than that. So for example, if you have a one-bedroom unit that's a one-bedroom unit, the fair market value is $2,081. That's what has been determined by HUD the unit is worth. If the tenant owes less than the $2,081, let's say they owe $1,000 only, then the owner cannot serve a 3-day pay or quit notice. An owner can only terminate the tenancy for non-payment of rent if the amount is owed is more than the $2,081. And the amount changes depending on the total number of bedrooms of the unit. This is the reason why on notices to terminate tenancy for non-payment of rent, the owner must include on the notice the total number of bedrooms. If you have follow-up questions on the topic of today, you may submit a question via our Ask Housing app at any time by going to housing.lacity.org/ask-housing. You could also call, a tenant could also file a complaint with our department by calling our hotline at 866-557-7368 or filing a complaint online. An owner may also call our hotline with any follow-up questions. And lastly, a tenant and an owner may look for any updates on our website at housing.lacity.org. And you will go to our homepage where you can search for various things, including renter protections. Once again, this is our general hotline. Anyone can call us with questions. You can also RSVP for future workshops on future topics. And you can sign up for our electronic newsletter, which we recommend. This is the way that we will announce any changes to the law or any reminders that may be important to tenants and owners. Thank you for your time.